Welcome to the Crystal Fedeli podcast. I am your host, Crystal Fedeli. I am a social researcher and policy analyst, speaker, consultant, and an award-winning nonprofit founder and executive director. And all of my work focuses on helping us to understand coercive control, helping organizations to understand coercive control so they can respond better, and helping individuals understand coercive control so they can navigate the systems that they need to navigate better. And here on the Crystal Fedeli podcast at large, we examine when institutional norms and practices diverge from what the research calls an evidence-based approach, being based on science, research, the law, etc., and instead reverts into using what the research calls a practice-based approach based on tradition and opinion, and how it causes an immense amount of harm to very vulnerable and marginalized people. And that leads me into introducing you to a special series we are doing here on the Crystal Fedeli podcast called When Coercive Control Turns Financial, the Family Court Response and the Cascading Consequences. We see in the research and in practice time and time again when a woman attempts to set boundaries on the coercive control that she is experiencing, how the coercive control does not stop, because that's not how it works. Coercive control does not stop when a woman sets boundaries. It just switches forms and it intensifies until a person in power or an institution steps in and stops it. So she attempts to set boundaries, and most often it switches to financial. And we examine the family court's response and how that leads to so many cascading consequences. So welcome to the series.
So we are going to be embarking on a new series here on the Crystal Fedeli podcast titled When Coercive Control Turns Financial, the Family Court Response and the Cascading Consequences. And so this series is going to complement a white paper I wrote titled When Coercive Control Turns Financial, the Family Court Response and the Cascading Consequences. So same title. And for this series, I am going to kick it off by establishing the framework, which is very complementary to the white paper that I wrote. And so I'm going to kind of just go through the framework for this entire series and for that paper. And then we are going to alternate having experts on, professional experts, as well as expert survivors on. And I say expert survivors because while I believe that professional experts are experts in their specific profession or educational background when it comes to coercive control, domestic abuse, domestic violence, I also believe that survivors are experts too. Survivors are experts on their will, what they don't will. They are experts on living inside of coercive control, like really in the trenches, right? And they are also experts on what is happening in their individual cases. And so we are going to have both professional experts and expert survivors on the podcast, and we are going to alternate professional expert, expert survivor, professional expert survivor. And then midway, I'm going to come in and we're going to kind of discuss the different patterns that we're seeing from the professional experts and also the expert survivors. And then we're going to go back to alternating between professional experts and expert survivors. And then we are going to tie it up by me doing one more solo episode just to kind of recap everything and really just kind of explore what we've learned throughout this series. So we are going to have professional experts on. We are going to have attorneys or lawyers. We are going to have people who, work micro individually with, expert survivors. We are going to have professionals who have worked with the coercive controlling perpetrators, right? We are going to have individuals who work on a more macro level in this field, who are out there advocating for legislative change, policy change, just really top down changing the system, in addition to obviously having the professionals who I described earlier who are doing the bottom up approach, who are really in the trenches working with expert survivors. And we're also going to have expert survivors on, individuals who have lived or who still are living in coercive control, and especially when coercive control turns financial, the family court response, and who unfortunately are living in or who have lived in the cascading consequences of that specific handling of when coercive control turns financial by the family court. So I am running this almost like a qualitative study, but it's not an actual research study. So I'm a researcher by education and profession. And so that's part of what I am, right? And so this might be a recap for all my researchers out there. So bear with me, but I just want to make sure we're all on the same page. So in research, we have qualitative, quantitative, and mixed methods. So qualitative is when you get like all these different you do maybe like interviews, for example. So you don't get a lot of data, but you do interviews and you kind of see the patterns throughout the interviews. Now qualitative is where you get the mass data, right? For example, you'll send out a survey and you'll have a ton of people fill out the survey, and so you'll get this mass data. That's not what we're doing here. We're doing qualitative. And then of course mixed methods is when you're doing both qualitative and quantitative. And of course, this isn't an actual research study. This is not IRB approved. So an IRB stands for Internal Review Board. So research is a very regulated thing because we have to make sure that we are being very ethical with the research subjects. And so what you do when you want to do a research study is you get it approved by an IRB, and institutions like colleges and universities, for example, will have an IRB. And so they work with the government to make sure that the research is ethical and that no one's being harmed, et cetera, et cetera. But that is not what this is. My goal is to have this turned into that someday. And so behind the scenes, we are working on that. And, what we're doing right now is, while it's more of qualitative style, it's in a very informal sort of the informal research phase. So before you even begin, the research, you kind of go out there and you informally interview people, or you collect data somehow to kind of just assess what kind of actual research study you want to do. And so that's what this is. This is more of the informal data gathering phase, but it kind of runs more qualitative. Does that make sense? Did I explain that well? Okay. Anyway, and so sometimes when I explain things, I'm like helping myself to understand what's going on. So I'm like teaching myself. But anyways, and that's why it takes me a little bit longer to explain things. Okay. What can I say? I have an artist brain, I'm in the lab. I'm making my beautiful artwork, and I won't emerge from my cave until it's finished. But you're here with me in the cave. Okay. No. So anyway, let's get to it. Crystal, focus. All right. I do have ADHD, by the way. Okay. So let's talk about the framework now. Now that I've told you sort of what the series is going to be comprised of, now let's really get into the framework. And this really follows the progression of my white paper. And it's sort of the interview progression that I'm going to take the professional experts as well as the expert survivors through in each interview. Of course, the professional experts are going to be talking about it from a professional expert standpoint and their specific professional expertise standpoint, whereas expert survivors are going to be talking about it from their expertise, which is actually living it. Okay. So the first part of all of this is domestic abuse, domestic violence, coercive control. And so there's this misconception that domestic abuse is an incident-based, physical-based model. So what that means is, well, there's an incident where he hit her, and maybe there's another incident where he hit her, but it's just an isolated event or events, and it doesn't really affect anything else. And so, we just need to keep the case moving and blase, right? But here's the thing, that's the old way of understanding domestic abuse, domestic violence. The new model to understand domestic violence is one that I ascribe to more. And thank God a lot of the professionals are starting to ascribe to more. And that is one where we look at domestic abuse and domestic violence from a coercive control framework. So, where the underlying root driver of the domestic abuse, of the domestic violence, is coercive control. And that means that the perpetrator of the coercive control is seeking to have power and control over their target and through whatever means possible. And so what we see with coercive control, when the root driver is coercive control, is that it doesn't stop because a survivor sets boundaries. So, for example, if the coercive control was manifesting in the relationship, physically, sexually, psychologically, so she can set boundaries if the coercive control was manifesting or happening physically or sexually, right? Because she can go to the police, she can go to the cops. Now, I know that there's issues even with that, but just bear with me here. We're not going to get into all the nuances of that, which is important to get into, but we're staying very focused in this series. So she can go to the cops, and for the most part, police will protect her if it's happening sexually or physically, because as a society, we agree that women should not be harmed physically and sexually, especially against their will, right? Um, and then if it's happening psychologically, we also do agree that women should be able to set boundaries from harm that's happening mentally and emotionally. And so, for example, she can say herself, she doesn't need to go to an authority to do this. And again, I know there's issues with this too, but just bear with me. We're not going to get into it for the purposes of this series. A future series we can, but for the purpose of this series, she can set boundaries and say, hey, moving forward, I'm available for communication only about the children, only about absolute necessary matters that need to be communicated, and I'm only available via text message, whether that be through a text messaging app or whether that be through a parenting app, etc., etc. Now, here's the thing though, because of how coercive control works and why I specifically created the nonprofit, because what will happen is she'll set the boundaries from the abuse not being able to continue to happen sexually, physically, mentally, and emotionally. And so, because the underlying root driver is coercive control, it won't stop. It may stop psychologically, physically, and sexually, but it won't stop overall. It will just switch forms, and it will switch often to financial. And so what I was finding is that there was this group of women who they needed the legal support, but because the coercive control had turned financial and because of how the family court views this and therefore how it handles this, they were out of luck. They had no support. And so as an entrepreneur, that's why I created the nonprofit. So okay, so the coercive control switches to financial. Okay, so then we get into the second section where it's the system entry into the family court, because where else is she going to go? She has to enter the family court system. There's no other system that can even help her when it comes to, financially. So she has to enter the family court, and now she's entering under conditions where she has been cut off financially. So she can't even afford basic necessities for her and her children: housing, food, gasoline, medical needs, let alone her lifestyle is severely degraded, right? And she is also not able to afford legal support. So she's not able to understand what her rights even are. And her rights are in the statutory and case law. And so she doesn't get to have a comprehensive understanding of what her rights actually are from a licensed lawyer or attorney, right? And then she certainly doesn't know how to get there and procedures the vehicle to get from rights violated to rights restored. By the way, as a disclaimer, this is for informational purposes only. This is not legal advice. But so she doesn't get to have a comprehensive understanding, let alone legal support to procedurally get from her rights violated to rights restored. And thirdly, I would say that there's also an added layer that she's in this situation financially and can't afford the legal support because of a continuation of a pattern of coercive control. So she enters family court completely hypervigilant. She is in complete trauma response mode: fight, flight, freeze, or fawn. And that's how she enters family court. Now, let's juxtapose it with how he enters family court. So he enters with an elevated lifestyle. So he doesn't have to worry about basic necessities. He has elevated his lifestyle. And we see this often. Like he'll buy a second brand new vehicle, or he will refurnish his new home that he has now. Let alone he gets to go out and, do all these, fun, cool things because he has all the money, right? Secondly, he gets to understand what his rights are because he can more than afford legal support. And he can understand procedurally how to get there because he can consult with lawyers and attorneys, plural. And then also, he can hire counsel to advocate for him to get there, right? And then thirdly, he is not being coercively controlled, he is doing the coercive controlling. And that is how he has learned how to regulate his nervous system, and so he's entering family court not hypervigilant. He's entering pretty calm and pretty, solemn, and he appears to be reasonable, and he appears to be the calm one. And so, what the family court does, though, and this is what I refer to as the credibility inversion, they look at him like he's the credible one, and they look at her like she's the unstable, non-credible one. And this couldn't be further from the truth. It's a credibility inversion because she's the most credible one in that courtroom and he's the most uncredible one in that courtroom. But that's how the family court typically interprets this. Take a swig of my coffee for people who are just listening audio. Okay, and so then we get into the third section here and the cascading consequences of all of this. So, because the family court just kind of addresses this as, oh, it's just one issue among many. And, well, there's other things that we have to prioritize first. And this is just a support dispute. It's not a pattern of coercive control. He's not trying to have power and control over you. It's just you want more money. And, I mean, why aren't you working? It's just how they look at it and how they handle it because they don't see it as, first of all, very important. It is very important to be on equal footing financially. Um, it's just because of how they look at it. There's so many cascading consequences. And I just want to point out that, you would look at our laws, statutory and case law, and is it gendered? Um, is it patriarchal? Is it sexist, etc.? Is it benefiting men over women? And the answer is, if you read the statutory law and the case law, the answer is no. You would actually think that it actually benefits women. But here's the catch. There's a difference between what the law says and the institutional norms and practices of the family court. And that is really the overall sort of critique and awareness that my entire life's work brings beyond this series. That's why in the opening you hear me say, when this podcast specifically explores whether we're talking about family court, whether we're talking about the addiction field, the trauma recovery field, when institutional norms and practices diverge from an evidence-based practice, and the evidence base is based on research, science, in this case, the law. Like, what's our reference that we're referencing how we're practicing? When it diverges from an evidence based practice and it instead uses what the peer reviewed literature refers to as a practice based approach, which the peer reviewed literature defines as being based on tradition and opinion, that is where harm is caused. That is the sort of thesis of my entire life's work. And in this case, it causes harm to very vulnerable and marginalized women and children. And so there is a difference between what the law says and the institutional norms and practices of the family court. And so that's what I'm trying to bring awareness to here, and I'm trying to highlight here. So, okay, so here's the thing. Because of how the family court handles these disputes, it treats it as a dispute. It treats it as just a support dispute. It doesn't treat it as stemming from coercive control that is now turned financial. And so they don't prioritize it with the urgency that it needs. But I just want to point out that it's interesting that the family court prioritizes institutionally custody and co-parenting over finances, because I just want to point out, and I'm not saying this is intentional, this is in effect regardless of intent, but I just want to point out that historically and still today, men are the income earners or the higher income earners, and who are the ones who can seize full control over the finances. And I just find it interesting that finances are not prioritized. And I just want to point out that historically and still today, women are overwhelmingly the caretakers or the primary caretakers. And I just find it interesting that the family court prioritizes the custody and co-parenting. I'm not trying to say the system is patriarchal or sexist. I'm just making an observation, and I'm just telling you what the effect appears to be. And this is from somebody who never spoke like this a few years ago, just so you know. But I have noticed that institutional norms and practices make this a topic that needs to be talked about. Okay. All right. So this has cascading consequences. So I have seen, and you will see in the series, that this has long-term financial consequences. This has consequences on custody and co-parenting, the way the family court addresses the coercive control that turns financial. I have seen litigation abuse, et cetera, et cetera. And so the family court not addressing very soon, and with the severity that it needs to be addressed, the coercive control that turns financial, it cascades into long-term consequences, and it is outcome determinative. So you will see on this podcast series, I mean, there's a woman who was locked out of divorce proceedings, and the coercive controlling party got a divorce by default and got all the assets and the kids because she was cut off financially, and she couldn't even afford basic necessities, let alone legal support to understand how to get the notices, how to file things, et cetera, et cetera. Outcome determinative. There was an individual who you will see has not seen her kids really for 2 years because the financial coercive control was a part of a long-term pattern of coercive control. And it turned financial, and she was struggling to afford basic necessities, and she couldn't afford legal support all at the same time. And so she psychologically broke. And so she did the responsible thing, and she went and got help, support from the psychological professionals. And what did he do? He used that to go and get temporary custody. And so now she can't see her kids other than when he lets her. But now he has the new girlfriend who is taking over, taking care of the kids. And the judge actually said, you know, he can have the kids watched by whoever he wants, and we'll wait till trial to address you having parenting time. She hasn't even had parenting time for 2 years, has barely seen her kids other than when he let her. But now that he has a new girlfriend, he has no need for her to watch the kids. And let's not even talk about the long-term financial consequences. There's a reason why the data tells us that men's net worth stays the same or goes up after divorce, whereas women's net worth, it plummets down into poverty. Then there's another woman who is in constant litigation abuse. I mean, constantly. She is in court every week or a few times a month, because, and this is what Lundy Bancroft said after we finished recording. He's like, oh, darn it, I should have mentioned this during the podcast recording. Please tell your audience. And so here I am, Lundy, I'm telling them now. But he was like, a lot of women, they'll just let him have all the money because they just want the pain to stop. And this is not what Lundy said. This is what I'm interjecting, because what will happen often, this is my interjection on what he said, but is that she'll be starved out. I mean, they let him have all the money. They send them into mediation. He has counsel. She doesn't. She barely has enough even for basic necessities, and so she'll accept an offer that's less than equitable and ideal because she just wants the pain to stop. She just wants to have some money to feed her kids. And the family court, with the way they address these things, these matters, they set it up to be that. They set it up to give him advantage, and that becomes outcome determinative. So it is not neutral to not have the parties on equal footing financially. It is outcome determinative, and it is foreseeable. Anyways, and so now this is getting back into what Lundy said. They'll let him have all the finances, because and what he'll do is he will then, after he has all the finances, just so she can have the kids, he'll come back and he'll use those finances to take the kids. And that is what happens time and time again. So that is the framework. That is the progression that I'm going to take you through in each episode, whether we're talking to a professional expert in their specific niche or we are talking to expert survivors in their specific niche of being the people who have actually lived through this or who still are living through this. Now, we don't cover this in each podcast episode, but this is covered in the white paper. And that is, I want to talk about the fact that, because my whole answer to this entire problem, okay, and you'll read about it if you read the white paper, is that the solution is for the family court to just follow existing matrimonial law. Isn't that so devastating? We don't need all this coercive control training, which I think is helpful. And I'm not discounting that we need it. But what I'm saying is that for this specific issue, we don't need coercive control training. Just follow the law. Just follow the law at the temporary phase. Okay. So, all right. So here's what the law says. And again, this is for informational purposes only. This is not legal advice. I am not a lawyer. I am a former paralegal. I used to do all the legal research and writing under the supervision of an attorney. I'm a social researcher and I'm a policy advocate, analyst, whatever you want to call me. Those are my 2 graduate degrees. I am in the midst of doing what I need to do to take the LSAT so I can apply for law school because I'm done with this. Put me in, coach, put me in the ring. Like, I'm done with this. Like, I need to get in there and fight. Let's go. Let's take down these coercive controllers. Somebody needs to get in there and fight for these survivors. Anyways, but I am in the process of that. But what was I going to say? So I want to cover, and from the standpoint of New Jersey law, because I haven't researched the law in the other states, but I am from New Jersey and I want to talk about New Jersey law. So I want to talk about the statutory law, the case law, procedure, and doctrine. Okay. So statutory law. NJSA 2A34-23 says that both parties are entitled to equitable access pending proceedings. I would argue that if I was a lawyer, that that once the initial divorce complaint is filed, proceedings are pending. And NJSA 2A34-23 says that both parties, not just the income earner, both parties are entitled to equitable access. Okay. And equitable is not that subjective of a term, even though I've heard some attorneys tell me that, well, equitable means it's very subjective. No, it's not. No, it's not. Equitable was created, I would argue, because we found that equal was actually not sufficient, because it sounds good on the surface, equal 50-50. But because, for example, she might have the kids more and he can work more, just splitting assets 50-50 is not sufficient, because he might actually end up with more because he leaves her with the kids, for example, right? And so that's why equitable was created, to actually make the outcome equal. We might have to apply an equitable approach to how we divide up the assets. And so what we'll see oftentimes is, we'll see like 20 something, 70 something splits of the, liquid funds in the temporary phase. And that's not equitable. That's nowhere near equitable. Okay. And so we, and then, so here we go. Let's get into the case law now. So I've established that, right? And we really need to follow the law. I just find it so interesting that at the temporary phase, it's just like the statutory law is not followed by any means. And there's all these reasons given for it. Like, oh, we're narrowing the case. Hold on. I'll get to the case law in a second here. I want to get on this tangent. I'm going to ride this wave right now. Okay. Let's talk about it. Narrowing. Oh, narrowing versus expanding. Okay. Here's my thing. Okay. So if we are narrowing something, because that's what a lot of these family law professionals and judges will do, they'll say, well, I'm reading a narrowed version of the statutory law or a narrowed version of the case law. Here's my theory on narrowing. If I have a 2x4 and I narrow the 2x4, let me measure it again. Is it a 2x4 or is it like a 1x3, for example? So if we are narrowing something, that means that we are doing something that we're actually not supposed to do. But we're using almost a euphemism of narrowing to placate you into making me think that I'm doing something permissible when I'm not doing something permissible. I'm making the outcome of something what it's not supposed to be. The original intent was supposed to be this, but because I narrowed it, I made it into something entirely different. Okay. Just like if I had a 2x4 and I narrowed it and I measured it again, well, now it's a 1x3. It's not a narrowed 2x4. It's now something completely different. It's a 1x3. Okay. So that's my theory on narrowing. Temporary. I have seen temporary not just be just days, not just be just weeks, not just be just months, which is unacceptable in the first place. But I have seen it be years. And my whole point is that it actually becomes outcome determinative. So temporary, first of all, is never acceptable. And especially when temporary is becoming weeks and months and years and decades and outcome determinative, no, temporary is not acceptable. There's a third thing that is used to justify this. Oh, discretion. Okay. Judicial discretion is supposed to operate within the bounds of the law. There's actually a legal definition of discretion. Again, this is for informational purposes only. This is not legal advice. But I looked it up. There's an actual definition of judicial discretion, and it actually is supposed to operate within the bounds of the law. And the problem is that there's a lot of judges who are saying discretion, but it's not following the law. And so I would actually make an argument that there are many judges who are improperly using their discretion, and that needs to be held accountable. It really does, because it's harming very vulnerable and marginalized people, and particularly women and children who are leaving coercive control. Okay, now let's get into the case law. So, what was I going to say? Now I forget. Sometimes I get into a tangent and then I forget the purpose of why I was bringing, the thing up in the first place. The point has left me. I'm so sorry. But let's get into another point. So Malamo vs. Malamo, caretaking is equal economic contribution. So income generation is not just working. It is working plus caretaking, just like we're doing an elementary math problem, right? Equals income earning. Okay. And so that's why both parties are entitled to equitable access pending proceedings. And there's a reason why both parties are entitled to equitable access pending proceedings, because whoever has more access to the income can basically control the case, and they can have litigation advantage as well as an elevation in lifestyle versus a degradation in lifestyle. So it's very important to ensure that both parties have equitable access pending proceedings. Then there's Cruz v. Cruz. So Cruz v. Cruz basically is that both parties, is it Cruz v. Cruz? I think it's Cruz v. Cruz. Both parties are entitled to the maintenance of their marital lifestyle. So if she has a severe degradation in her lifestyle, well, that's unacceptable because she's entitled to maintain her marital lifestyle. She's entitled to a transition period where she transitions back into the workforce and she's not severely economically degraded during that transition. All right, now let's get into doctrine. So doctrine is created when we have a bunch of case law. And obviously case law it sets precedent. So it's like, okay, here's the statutory law. Here's the specific set of facts of this case. This is our decision. And when we have a bunch of similar sort of cases, right, where here's the statute, here's the specific set of facts, and if there's a similar specific set of facts, and here's the outcome, if there's similar, well, then we have doctrine. We create doctrine. And so there's something called the doctrine of the maintenance of the marital financial status quo. The problem is that courts narrow it in the temporary phase. But I told you about my theory about narrowing. and about judicial discretion. I think it's being exercised improperly, and inconsistent with law. And it's very harmful, and it's very crucial that this stops and that this is held accountable. All right. So there's the doctrine of the maintenance of the marital financial status quo. And so she is supposed to have her marital lifestyle maintained until the support calculations and all those things, are determined, but that's not happening. The doctrine's not happening. So, that's the issue right there. I really wish I could remember that point I wanted to make. It was a really good point too. It was from Malamo vs. Malamo. Oh, I can't remember what I was talking about before. Okay. It was like right in the transition too. It was in the transition from family court entry into cascading consequences. Darn. Okay, I can't remember it. I'm sorry. All right, but anyways, so basically my whole point is that the whole solution to all of this is for the family court, especially in the temporary phase, to follow existing matrimonial law, and this entire thing would be solved. So that's the framework. That's the framework for the white paper. That's the framework for the podcast series. And yeah, so I really hope that you enjoy the series. I have poured my heart and my soul into this project, and it is really the basis of the nonprofit You Made a Way. It's to support these women who, when coercive control has turned financial. And so my whole solution is to follow existing matrimonial law. And that's what You Made a Way seeks to do as an organization, boots on the ground, to help women through the legal clinic, gain the legal support they need. And then obviously, yes, the coercive control training, which is what I do through my part of what I do through my private speaking practice and training practice, where I offer trainings and speaking to organizations and events. And then also really creating some systemic change here. Really, for me, the law exists already. It's just a matter of it being followed. And so, my recommendation for a systems perspective is procedurally for there to be a cap on when pendente lite. So that's Latin for pending proceedings, spousal and child support, regardless of the parenting and the custody and co-parenting, there needs to be a cap on how long a court can allow a woman to be a caretaker, rather to be under what they would call a household expense order. And in fact, I think there needs to be solutions where both parties are restrained economically, not just the caretaker. And yeah, I think it needs to be days or just weeks where the financial information is ordered. And we set that temporary support number, and it needs to be very close to her, marital lifestyle. It can't be that he just gets all the liquidity and she barely gets anything. She's lucky if she even gets money for food. No, that's unacceptable. And she should not be placed in a, request reimbursement framework where she has to request every time she needs a car repair or a home repair, and then he gets to approve and advance the funds. No, that puts her right back in a coercive control relationship that she left, but that's the institutional norm and practice of the family court. And ladies, you need to consult your licensed attorney, but reject it. You can take positions. That's not legal advice. That's for informational purposes. You have to consult a licensed attorney, but that's my way of viewing it. So, all right. And so that is that's my recommendations. I mean, I think the laws exist already. I think we just need to have procedure. And I know the Supreme Court in the state of New Jersey writes procedure every year. And so that is my recommendation, to have that. And then also, we need to have judicial accountability more than just the Judicial Oversight Committee. judges do need to be held accountable, and not in a bad way, like they're in trouble, because I think a lot of judges are not doing this on purpose. I think they just don't know, regardless of intent, in effect, what they're doing. And really, nobody knows the intent of somebody's heart. The Bible actually says that. And I actually think whether you believe in the Bible or Jesus or not, that's a really good, sound principle. You literally have no idea what somebody's intentions are. And even if you think you do, you don't really, because you're not inside their head and heart, right? And so, irregardless of intent, in effect, this is happening. And so, we do need to have oversight. And really, I don't know about you, but I know when somebody's looking over my shoulder, I'm more apt to, stay on track. Although I'm a really good moral person, so I'm typically doing the right thing. But sometimes I slip, and especially coercive controllers or bad actors. If they know somebody's watching, usually having that accountability and that oversight keeps them on track. And that's just psychology 101. And so I really do think we need more accountability and oversight for judges, regardless of intent. So anyways, I think it helps. So I'm going to stop talking. That is the framework for this series. And so I really hope that you enjoy it. Now go check out the first episode and binge watch it. 1, 2, 3, 4, 5, 6, all the episodes. All right. See you soon.
Thank you for joining us for another episode inside of our series called When Coercive Control Turns Financial, the Family Court Response, and the Cascading Consequences. If you are an organization or an event and you are looking for organizational consulting, speaking, or training so you can understand coercive control better, so you can respond better, I want to invite you to go ahead and visit me at crystalfedeli.com. If you are an individual leaving coercive control and you would like support navigating, I want to invite you to go ahead and also visit me at crystalfedeli.com. And if you are interested in specifically supporting You Made a Way, it is the 501c3 nonprofit that I founded and I am the executive director of. If you are just as passionate as we are of making a way for women and children who are leaving coercive control when it turns financial, I want to invite you to go ahead and visit us at youmadeaway.org. And we hope to see you back here next time for another episode of When Coercive Control Turns Financial, the Family Court Response, and the Cascading Consequences. See you then.